everyone. Welcome to the Reservation Resources and Economies panel. We're happy to have this panel moderated by Dan Lorenz from the Native Americans. The Native American Rights Fund.
Dan joined NARF as a staff attorney in 2017. Before joining NARF, Dan was an attorney advisor for the U.S. Department of the Interior, Office of the Solicitor, Division of Indian Affairs. He was a law clerk to Claudia Wilkin in the Northern District of California, and also with the Honorable Leo Brisbois in Minnesota. He was also an associate in the Oklahoma City Office of Hobbs, Strauss, Dean, and Walker.
Dan is a member of the Iowa Tribe of Kansas and Nebraska and earned his JD from University of Wisconsin Law School, where he graduated cum laude in Order of the
Dan, the floor is yours.
Thank you, and thanks for inviting me. I'm one of the people here at Wisconsin who did not make law review back in the day. But then again, so is Cecelia Klingele, and you remember when they introduced her, they said that she clerked for the Supreme Court. So we're happy that law review has accepted us into this forum. And since they did a great job of introducing me, I don't really need to introduce myself. On this panel, we're going to hear from Dale White, who's the attorney sitting closest to me, John Clancy on the far end, and Reed Chambers, who I think is joining us online. CLE credits are available for this panel in the states of Arizona, California, Colorado, Illinois, Iowa, Maine, Michigan, Minnesota, Pennsylvania, Washington, and Wisconsin. For those attending virtually, there will be secret words administered by the panelists throughout the actually not by the panelists, by me, that you need to report for your CLE. You must report those words on your CLE handout provided provided to you by email before this event. Please pay attention for those words as they're necessary to receive your CLE credits. And for those of you who are attending in person, just track the number of minutes you spend at this panel and indicate that on the CLE program. There are background materials that accompany these presentations. The Symposium website will have those. And the background also provides biographical materials. I'm going to skip reading the bios for our panelists so that we can save that time for Q&A. At the end of the presentations, there will be a short Q&A. And if you have questions and you're attending virtually, we ask that you provide that question in the chat, and we will hold that question until the end of the presentations. If you're in person, just raise your hand, but please wait for the microphone, because that's going to make it easier for the people online to hear your question. And with that, I think, since I'm not reading bios, it's my pleasure to welcome you to the Wisconsin Law School, and we're going to hear from each of the panelists in the order they were introduced. So with that, Dale.
Thank you, Dan.
Everybody hear me? Okay, thanks. Good afternoon. I want to thank the Wisconsin Law Review for inviting me to speak here today. I'm glad to be presenting on this topic of Indian economies, reservation economies, and resources. I'm going to discuss more the economy part, economic development. It's an issue that I've worked on extensively over my career, especially for the last 15 years as in-house general counsel for the St. Regis Mohawk tribe in New York, which happens to have many diverse and robust businesses on the reservation. Retail, hospitality, cigarette manufacturing. We have about a 5-mile stretch of Route 37 that I would guess has 50 different retail stores on it. So you can imagine what kind of economy that is. Most of our economy is actually developed by individual tribal members. We have a modest-sized casino that is the only business that the tribe operates. It has some startups in progress, hoping to get some 8A businesses going. We have a Section 17, but right now the casino is the only economic development undertaking by the tribe. It's done by tribal members. And we're also beginning to license adult use cannabis as well. I've been active in that for about 2 years. New York State legalized it in March of this year. So I'm up to my neck in that, not literally, but so my focus today will be on businesses, reservation business, economic development. And I want to focus in particular on one rule that is in the new restatement, which to me is an example of a law that was developed a long time ago at the beginning of my legal career in the 1970s, late 70s, early 80s, that was a product of history, of politics at that time, which is a lot of what Indian law is. It's shaped by the conditions at the time and the fact that William Rehnquist was on the Supreme Court at that time. And so that conservative court made a lot of the rules. So what I want to cover, and this one is a rule that allows, it's really bad law because it allows states who under the original Worcester model had no authority on Indian reservations. It allows them to encroach and intrude and impose their taxes and regulations on tribal businesses. So what I want to cover is on the screen here, how the rule was created, some origins of it, which I think is important, why it's bad, what the impact has been on my reservation and on other Indian territories. And then finally, what can we do about it? This is all about the restatement. We have black letter law that's going to be included in the restatement book. But I don't think that we should necessarily think that just because it's black letter law restated makes it static, that it's capable of being changed. Otherwise, we're in a really bad situation because we're locked into rules that were created, that created bad law, like I'm going to talk about 40 years ago, locked in forever. So I'm going to talk about it, and this is actually a topic that I was thinking of writing a law review article about, and I'm going to turn this into a law review article that's my working title, which is branding reservations as tax havens, the rule created in Mullen Colville and why it must be changed. So let me move on to the next slide. And this is a restatement. I won't spend that much time on it. It's section 30 of chapter 3. It's also referenced you'll find the economic development section, the bulk of it in chapter 4. This cross references to this. The rule stated is, based on the cases that I talked about and others in the 70s, it's presumed that states can impose their taxes and regulations on non-member activities in Indian country. And I'm going to talk specifically about those non-member Indian activities I will deal with would be those going on the reservation to do business on my reservation, business on other reservations. Now, it's presumed that state can, and then these three factors here, a tribe can rebut that presumption if there's an express federal law. And then if it's impliedly preempted by federal laws, which you no doubt familiar with, which is the Bracker test. And the last one is whether it infringes on tribal self-governance. Okay, the history of the rule. The Moe case, Moe versus Salish and Kootenai tribes in 1976, and then the Colville case 4 years later. Again, this was influenced by what was going on in the 70s. I believe, and I'm sure that I'm right, that Moe was the very first Supreme Court case that dealt with state authority in the context of modern businesses. Before that, reservations really did not have many businesses, had minerals that were being exploited. The Northwest tribes had fishing treaty rights, and other tribes did. And so it was basically common to have trading posts on reservations. On our reservation, I know that for a fact that if you looked at a photo of early 1970s, there were no businesses on the reservation. So what happened was it created a perfect storm. In the 70s, we had tribal resurgence. Tribal sovereignty was on the move up. The federal government was supporting it through the 1975 Self-Determination Act. There was funding for tribal governments. You had red power at the time. So tribes were really getting into businesses and exercising their sovereignty, all because of the events that happened back then. On the other side of that, you had states, particularly in the West, where they had aggressive attorney generals who didn't like that. States did not like the fact that here are these Indians, they're starting businesses. This is not good for us. You had, I'm sure that you've studied it, you've had the cases in the Northwest involving the treaty fishing cases. That led to violence in the Northwest. Tribes were asserting their sovereignty, exercising the right to treaty fish, and you had state attorney general, the state governor out there blocking that. So that's really the background for Mo. And what happened in Mo was that it's actually a classic case of bad facts make bad law. So you have the first business, and so what is it? It's a smoke shop. It's a smoke shop on the Flathead Reservation, selling cigarettes at discount, selling them without paying state taxes, and they were attracting customers. And the thing about Flathead Reservation that makes that case, I think, an outlier, is that the Flathead Reservation was opened up, and I believe it has almost 80% of the land owned in the Flathead Reservation is owned by non-Indians. So it's very small, 20-something% of the population of Flathead. So it's largely checkerboarded. So the Montana Attorney General went in. He tried to seize cigarettes. He tried to stop the state. This is an individual Indian on the Flathead Reservation who had this smoke shop. The result was the case ended up going to the Supreme Court, and the court, it's odd because I looked at the transcript of this argument. Here you have the very first time that the state is seeking to have its taxes upheld in this case. I looked at the oral argument. The oral argument had very little argument about the issue that I'm talking about today. It talked about the procedure, how it got there. It talked about the fact that the reservation was opened up. It was a largely non-Indian character. So that influence. And one thing that some people forget is that the Attorney General in Montana was essentially saying that this was a tax haven that was illegal. It was argued that it was a misdemeanor for that non-Indian to go on the reservation and purchase it without paying state taxes. So it was all clouded. And the court came out in a remarkable opinion. Its opinion is very short, and a short paragraph that cites no law whatsoever. It cites to the district court's finding that the incidence of the tax was on the non-Indian. It cites to the impact on the state of losing those tax revenues, not a single case. So that then brings us to Colville in 1980, 4 years later, where the Supreme Court took another smoke shop case, this time because it was a tribe that owned and operated the smoke shop. The tribe itself was imposing the taxes. The tribe was regulating it. So it was a very different case. And so I think a lot of people at that time probably thought, okay, this is going to be different. You've got the tribe actually being a part of this. And obviously the Supreme Court took the case. It didn't deny cert. And because of Mo, it thought that this was something that made it different. This is something I'm going to cover in my article. I think it's very fascinating, is that you had in oral argument in the Colville case, basically pitted against each other two legendary figures. You had on one side, Louis Claiborne, who was probably argued in the 70s just about every single Indian law case. And Google him and you'll see how interesting he was. He's referred to in a book about the Supreme Court at that time of being the 10th justice of the Supreme Court. He argued a lot of Indian law cases, and he had a lot of influence in the court, with the court. And then on the other side, you had Slade Gorton, who was the Indian fighter from the state of Washington, very anti-Indian, aggressive, went on to become a U.S. senator, fought tooth and nail against against tribal rights in the Northwest, especially treaty fishing. So what happened was the arguments were very starkly presented. You had, on the one hand, Claiborne arguing that, hey, wait a minute, this is not Mo. This case is not Mo. You got a tribe involved here. The rules are different. And he pointed out in the argument that the burden is actually the opposite of what Mo said. He wanted the court to go back to its doctrine, the Worcester doctrine, its precedents, where the state is not allowed to intrude onto the reservation to affect Indians and tribes unless Congress authorizes it. But in Mo, they had started developing a rule. They actually had the opposite. It was presumed that the state could tax, and the tribe was put on, had the burden. So he was saying, and he also said that because of the tribe's involvement, particularly, that this is a very serious impact on it. It's not remote. This is not just about the non-Indian who is thwarting state law. And here's a quote in the argument. He says it destroys a tribal enterprise, and it is a tribal enterprise and not a private one. He was then on the other side. You had Slade Gorton, who, if you look at his argument, I doubt that a state attorney general could make that argument. Any of the arguments that he made in that case, they were incredibly demeaning to tribes. He talked about he didn't cite any law either. He didn't have any law. He relied on Mo, and what he said was basically fear mongering. It was total fear mongering. He talked about the threat of tribes on the state, as if the state were some weak government. Here the tribes were damaging them. He made statements such as it would monopolize sales, that state power would be transferred from the state to tribal councils. And then he made this statement that was picked up in the press afterwards: tribal councils do not have a constitutional right to be parasites on the state system. So that's the flavor of the argument. And then 8 months later, the court issued its decision. And it upheld Slade Gorton's position. Here you had a case. Mo didn't cite any law. You Colville bootstrapped the Mo decision, and then in its decisions, in response to wait a minute, this is a tribe. This is not an individual. You're ruining their business. It said this case is primarily about economics, and there's a quote in there that talks about how it's painfully apparent that the goods here were not produced on the reservation. It was not generated on the reservation, and that it was generated from outside. So this particular revenue generated concept then was created in Colville, and so what it's done over the years is probably the most damaging thing, I think. These Colville cases, based upon the tribe somehow being involved in this illegal tax haven, that they can't sell cigarettes at a discount because it's hurting the state, was embedded in the analysis of every single case over the last 40 years. I looked at all the cases. Someone wrote an article in this year. He collected all the Bracker cases involving business on reservations. There were 64 of them. 19 of those involved retail. Only 2 of those cases did tribes win, and that's because, if you remember, I talked about the factors in overturning it. If you can point to an express congressional statute that allows it, and those were cases where you had businesses, stores that were located within a casino. So the court said those are okay because the tribe is doing something. The tribe is actually contributing to that. Every single other case that's been brought up, the tribes have lost because basically and here are the 8th Circuit, 3 9th Circuit cases, and then 1 10th Circuit cases. The only 2 goods sold on a tribal casino store, gross proceeds on a tribal bingo. You have ordinary businesses done on reservations in these other cases coming out of Arizona. The tribe had a shopping mall developed on the reservation, had a hotel, concessions, all upheld because the bar is so low for states. All they have to show, if there's not a federal statute, and there's not going to be also a comprehensive scheme where you're going to have it impliedly repealed, because that has only happened in the context of three cases: the Rama case, the Mescalero case, and the Bracker case, which had very comprehensive federal regulations. So that's what the court is. You're not going to find that. There is no statute that specifically comprehensively regulates retail sales. Kind of the last insult, I think, in a case is this one Quilceda village case in Tulalip. Now look at this. This is a case where the tribe had 2,000 acres on its reservation. It developed into a shopping center, a shopping mall. It funded $150 million of the infrastructure. The lands were on the reservation. It leased it out for a commercial center, provided all of the government services. The United States supported it. It passed a special leasing statute. It had its regulations encouraging economic development. It approved the leases. The United States kicked in $50 million. Look at what the state did. The state funded 5% of it. Its only interest in this was the 8.9% combined state and county taxes. It was taking $30 million in sales tax from this tribally developed shopping center. 30 million in 2015. Who's the parasite now, right? It's obviously the state. And the court said that this was enough of an interest to uphold the application of the state taxes on that shopping center. I think the judge tried to find a way to find preemption, but it said in the end, the Supreme Court and Ninth Circuit precedent has all but closed the door on preemption of state generally applicable taxes on activities between non-Indians. It's never found a single case. All right, so let me go to the third point. What are the strategies? A good thing is that in one of the Supreme Court cases, the Chickasaw case, the court was faced with another cigarette tax case, this one in the 90s, and it said, okay, you can impose the tax of state, but you can't enforce them. There's no enforcement mechanism because the tribe has sovereign immunity. Although, and then very helpful to the states, it added a footnote. Well, you can do this. You can seize the product. You can enter into compacts. You can sue under ex parte Young, and a couple of other things. The court was suggesting ways that they could get around it. So what's happened is that tribes have entered into compacts. And what happened in Tulalip, I called the attorney for Tulalip and said, is this case on appeal? And he said, no, on appeal, they had a mediator and they entered into a compact. It's not what they wanted. You know, they got all the business taxes, but only a fraction of the sales taxes because you're at the mercy of the state, essentially. So we can have compacts. And then the other picture is of the Osalasi manufacturing plant on Mohawk Reservation, where I was an attorney for that business for 6 years. We are being forced in New York to manufacture our own cigarettes so that we satisfy this rule of revenue generated product. And that's what we'll probably have to rely on too for our cannabis business. If you show that tribes have to go to the extent of growing and producing products in order to be able to sell to non-members who come on the reservation because of this rule. And you can't do it with every product. I mean, you can't have a shopping center and then have the tribe manufacture every single item sold in it. You could do it for cigarettes. You could do it for a couple more, I think. I think that with fuel, it was tried in some cases, but was not successful. You're not going to have refineries on reservations, at least not in all places. Long-term fixes, Supreme Court, no. I mean, it's a law that's been around for 40 years. Interior Department has been thought to getting regulations under the Indian Trader Statute. There was back in 2015 regulations that dealt with state preemption of state taxes, but the court said that's not enough. You have to have an act from Congress. So that leaves it up to Congress. And I put this in the category of wishful thinking. At some point in the future, I would want Section 30 of the restatement to read something like this. that states and political subdivisions of the state are expressly prohibited from imposing a tax, et cetera, on the charge on any sale or production of goods on trust or restricted lands based upon amendment of the Indian Traders Act. So it's not a static law, but we're forced because we have this entrenched decision of 40 years that's been harming reservations. We're forced to have to go to Congress. Thank you.
Thank you, Dale. And next up is John Clancy, who's also going to be talking about some economic development aspects of this, these couple chapters of the restatement.
Hi, everybody. I'm John Clancy. I'm an attorney at Godfrey & Kahn. I work with Brian Pearson closely on Indian law matters, and by background, I'm an environmental attorney, I guess, first, then an energy law attorney, and then I've also worked with tribes throughout at both areas. The environmental stuff has been mostly protection of reservation resources. I worked on the Crandon mine matter, for example, worked on the taconite mine matter up north with Bad River. And then in the energy area, I've been very fortunate to work with tribes that have been really focused on sustainable development. It's been a real honor to work with them on these issues.
John, I'm sorry to interrupt you, but I forgot to give the secret word.
Oh, go ahead. Yeah.
I just got a text from one of our online participants that says code word ? Which tells me I hold your CLE in my hands. The first secret word is business. And now I return you to our regularly scheduled programming.
Thank you. And I did not work on the restatement. I think it's fantastic, though, a fantastic resource. I'll try to point out things in my discussion. I don't really have slides on the particular parts of the restatement that relate to it, but it's everything that I've worked on has been based on principles that are in the restatement in this area. I'll talk about a couple things that are really just taking advantage of the present situation with technology and where things are going, the tribes can take advantage of. But I think there'll also be resources in this area brought in. And I think one of the key issues is, and it's a very amorphous concept, at least to me, is what's the general trust responsibility of the federal government to the tribes? One key issue is how they help out in providing resources to tribes, and then also how they protect tribes in these areas. And I'll talk about that, especially when I talk about funding for various programs that tribes have been able to take advantage of and to really meet, I think, both their economic and environmental goals in certain areas. So anyways, I'll get going. So I want to talk about, a variety of different topics that all relate again to kind of sustainable development and really getting reservations in working on opportunities for reservations to bring in modern technology that is consistent with their environmental goals. So I'll talk about clean energy development. I'll talk about microgrids in that context too. I'm working with the tribe out in California. They have tremendous reliability problems. The tribe's electricity coming to the tribe goes out about 3 or 4 times a year at least. It's a tremendous issue for their casinos, you can imagine, because that shuts that down for days at a time. It's a tremendous issue just for the reservation in general. And so they're working on a very complex microgrid project that is taking advantage of federal funding as well as state funding as well as tax credits to have that done. I'll also talk about tribal utilities and what I think is developing is the concept of tribal virtual utilities, taking advantage of certain situations tribes have as well as opportunities that other entities have, and to build out a system where you don't need to necessarily own and operate the whole electric utility system, but you get the same kind of advantages as you have if you owned it without some of the disadvantages, basically. I'll talk about EV charging because I think that's a huge topic going forward just in general for the United States, but also a huge opportunity for tribes. And I'll talk about sustainable housing at the end. So, with respect to clean energy, the big thing out there, really, the tribes I work with is that, well, two things. One is providing clean energy to yourself and your members. And the other thing is working on larger projects where you're bringing clean energy to the grid. Both are, important opportunities for tribes. I'll focus more on self-service, providing clean electricity to members to tribal housing and to tribal buildings, tribal enterprises. And the key issue there, I think, is the ability, because I think the federal government has recognized its responsibility to help bring resources into tribes in this area of very good, basically grant programs available for tribes. But then also leveraging that through the use of tax credit funding. And it really gets into the issues that are in the restatement in terms of how taxation works too. There's different kinds of entities. There's state chartered entities, which typically are taxable, subject to normal taxation, but which actually can be good in this context, because of the ability to bring in tax benefits then too, because we usually think about tribes as being advantaged because they don't pay taxes. In some ways, they're disadvantaged. They don't get the ability to receive tax credits and depreciation benefits, which can be actually more valuable in some contexts than being non-taxable. So we'll talk about that a little bit as well. And really just how this can all meet, environmental goals of tribes, which I've been, very impressed with all my work that that's the universal theme and an accepted theme that we need to be looking out for the future of this for tribal people and all people. So, one thing on energy is that these projects have to make sense. If you're doing a large energy efficiency projects for the tribes, or you're doing large or small clean energy projects like solar or wind, they have to pencil out themselves. They have to provide cost savings that make it worthwhile doing. So that's, one basic step. That's not really a legal analysis so much, but it has to be part of the projects too. But then in terms of bringing funding in, there's a very valuable and a very helpful DOE program, this DOE Tribal Energy Program that's been around for quite a while now, and it's financed projects on tribes throughout the country. And they have been fortunately increasing the amounts of the grants available. They're now up to $2 million. And actually, in light of COVID, as well as recent federal budget legislation, they've increased that further. So because of COVID, they allowed for tribes to come in and ask for cost share reduction, which meant actually a bigger grant. So I'm working with a tribe that basically has gotten almost a $3 million grant out of this because of the COVID situation. But then in the last federal budget, the Congress also recognized that, tribes have limited resources, that you shouldn't always require such a big cost share on these projects. So they're allowing for that to be addressed as well in the future. There's also funding, that's available under NAHASDA, but also under the Indian Community Development Block Grant Program, both under HUD, that could be used, in this area as well for clean energy development, can be very valuable. So the good news there is that, the federal government has established permanent programs that really help tribes in this area. And then we've oftentimes blended into those projects also utility incentives or private company incentives from foundations, things like that to help fill in the gap. And then, finally, I'll get to the next slide, I guess, the ability to bring in tax credits, to bring in a taxable entity into an entity with the tribe, a partner with the tribe to make, to get the kind of the best of both worlds, the non-taxable status of the tribe and the tax benefits of a taxable entity. So, and with these, with clean energy projects, oftentimes the federal funds and the state funds alone don't pay for the full project. But the ability to bring in a tax investor who can typically be in an LLC partnership, usually under state law, which means it's subject to normal taxation, means it's not subject typically to sovereign immunity. But in a lot of ways, that's not bad, because we want to have the tax benefits flow through to the taxable entity. They can receive both depreciation benefits and a 26% tax credit on the overall cost of the facility, which really is essentially becomes another grant source to really, in a lot of cases, bring the cost of the project down to zero. And then also the tribe, the typical arrangement is that the tribe is a member of the LLC, but it's also the taker of the energy. It has a contract with the LLC. And so it wants to be able to sue the LLC and really the investor if they don't do the right thing under that. So that's actually in some ways a good thing as well. And then I noted the potentially lower cost share for the DOE to make these projects really effective. So this has resulted in tribes in Wisconsin. Oneida has projects under this, Forest County Potawatomi Community, Mole Lake, and other, I can't remember who else that does, Bad River does. So it's really created great green energy projects on tribes in Wisconsin. I've also worked with tribes with the St. Regis Mohawk, their housing authority, and with the Spokane tribe and the Rincon tribe out in California. So it's been a really great opportunity for tribes, I think, to pursue their green energy goals and to really take advantage of what they have, what resources are available towards these projects. Now I wanted to talk, so that's typically a project that would serve the tribe itself. Another issue is, tribes are being approached now, and if you get involved in this area, you'll start to see more and more of it, tribes of land by developers for typically really large solar or wind projects or other energy projects, battery storage projects now as well, where the real benefit of these projects is more economic. Typically, there's rental payments that are between 3 and 6 times normal agricultural rents. So that can be an important resource to the tribes. They can also negotiate potentially for a piece of the pie, essentially in terms of equity in the project. So these are important as well. Here's where the trust responsibility comes in again, though, and it actually relates to the last one too, that when you bring in a separate investor into an area, which Dale deals with a lot, if you bring in a private investor on a private entity, anything that's not the tribe itself, the question becomes, how does the approval of lease occur? Which is typically, as I think you're generally aware, typically by BIA approval, which typically requires a long process. There's actually specialized wind and solar leases under the BIA leasing program, which can be used here. But for a lot, that could be a major kind of hurdle. It can be a time frame hurdle more than anything else. Typically, a lot of tribes are now looking at and have pursued Hearth Act ordinances to do the process themselves because of that. So it's interesting how the trust responsibility can kind of get in the way sometimes too on projects going forward as well. So then another issue then is how do these tribes, especially like the Rincon tribe I mentioned before, how do they improve their grit, their resiliency? I tried to work with was the Seminole Nation down in Florida. They had power going out for 2 weeks at a time every year, basically. So in those situations, it's very important to not only consider green energy and the benefits that can provide in terms of wiping out energy bills, but also how do you get resiliency? And fortunately, and this is another area where technology is really taken off. Solar and wind has gotten really cheap, and that's why we see all these wind projects, especially like in Wisconsin here. You're seeing 1,000-acre solar farms being developed, which I never thought that'd be possible. Here in the upper Midwest. The same thing is happening on the battery side now. The batteries have been going down in price at about 15% per year for the last about dozen years or so, and so you're starting to see these projects being developed that are not only solar or wind or other renewables, but also have significant battery storage, which then allows these facilities to disconnect from the grid and operate independently if a major outage occurs, which with climate change is pretty happening more often anyways, but there's, especially in rural settings, a real problem. Rural settings, and I guess the state of California, because California has all these forest fires, so you also have situations there. So this is an important area that tribes are looking at now too. Bad River, for instance, they put in solar plus storage at their major operations up north under that DOE program with tax credit funding that I mentioned before. So it's a really important opportunity as well, and especially again, if you're in the kind of rural area or area where the power is not reliable. And then, and just to note, this is another example of the federal government, again, taking the trust responsibility seriously. HUD has great TA programs, technical assistance programs, to help tribes develop plans for these kinds of projects as well. So I just put a slide that I usually have for tribes to be aware of, but it's also just important, I think, to be aware of here that there is efforts by the federal government in this area to really help out. Another aside is the Biden in his executive orders also noted that recently the requirement on agencies to basically do everything possible under existing authority to help out tribes in this area. Then I wanted to talk for a few minutes about this concept of virtual utilities. Tribes, a number of tribes have developed their own electrical utilities, which is fantastic. It's a great exercise of sovereignty and can provide real promotion of economic development, especially if they can provide power cheaper or better or more equitably on the reservation than just relying on a larger utility that serves, let's say, half of the state of Wisconsin or half of the state of wherever you're located, which could be great, but that's also a huge burden on tribes to take on that much. It also can create real political issues. If something goes wrong, the tribal council can face a lot of issues with that because they're a service provider to the whole reservation on this kind of critical resource. So one thing we've been talking with our tribal clients about a little bit more now is, in light of the great work that Kevin Washburn, in his leadership role in BIA did in creating the new right-of-way regulations, which Brian talked about yesterday, this really creates an opportunity for tribes to regulate and to tax and to set right-of-way fees for lines coming through the reservation. And so, we've been working with these tribes that have been starting to take advantage of this and getting significant payments on an annual basis for these lines. So they basically reversed it so that they, instead of paying to put in their own new lines, they're being paid for these lines to be on the reservation. And they can then also set standards for service on the lines and things like that to really get more sovereignty and control over those lines. And then by combining that with, clean energy development that serves their own homes, their own buildings, and taking advantage of the utility programs that are available to everybody, like they have these net metering programs, billing credits and stuff like that, you can kind of create what might be the best of both worlds, that you have essentially a utility that you control, that you regulate, but you don't have to operate. Then briefly on EV charging. I think the biggest development in transportation, as probably everybody's aware of now, has become the advent of electric vehicles. Obviously, Tesla's a company everybody knows about, but virtually every company is trying to catch up to them now. And the real driver for that is, as I see it, I guess at least, is, well, the real benefit for the environment is the ability to have these stores of energy that can take clean energy off the grid and help balance the grid based on how they're operated, and to switch out from fossil fuels into purely, wind, solar, and other renewable energy sources. The real economic benefit, though, is that, and I bought a electric car about 3 years ago, and I was just amazed by how cheap it is to operate. I think I've driven about 60,000 miles, and it's been about $1,200 to operate the car without any oil changes and all that kind of stuff. So I see that as really kind of the future for where we're going. And I think it's important that tribes are thinking about that too, because of the issue that, one, if you're in a rural setting, how do you address the range anxiety issue that everybody talks about? How do you make sure there's charging available in your rural setting? But then also, what's the opportunity out of that for tribes? And the economic development opportunity. And there's different levels of charging. There's level one, which is just trickles in energy. It doesn't really do very much. Level two is what you'd have if you plugged into like an outlet for a washer, washing machine that's really powerful, at 220 or 240. That gets you like 20 to 50 miles an hour. And then you get the superchargers that Tesla has and other companies that have put out now that are like 500 miles an hour, 1,000 miles an hour. And, the big issue, I think, is our big opportunity is when people, one, if you're in a rural setting or any setting, really, you can help bring in more customers if you have that charging available. Let's say if your casino, your hotel, your C-store, your restaurants. And the other thing is that, one, it takes longer to charge at these things, so people are stuck there. And two, they can leave their car. It's almost, you can't leave a car when you put a gas in it, but you can leave your car when you have electricity. And so this provides another opportunity for tribes to really be leaders in the clean energy world, but also bring in folks and have them come to their facilities, spend money at their casinos, hotels, et cetera. And then also there's funding available for this. I mean, actually, as of today, or as of yesterday, because of, well, not as of the signing of the infrastructure bill by the president, there's $7.5 billion that's going to go into charging infrastructure that tribes should be aware of and trying to take advantage of as well. As well as potential utility funds, potential state funds, as well as like even Tesla has the destination charges, which are level 2, that they will provide for free to a lot of entities as well. So it's a really key area, I think, for tribes to be aware of how they can be part of the clean energy future, but also make money off it. And then the sustainable housing, I just wanted to mention, my limited time left over, just that there's really 2 points in case I can't get to this all. There's a lot of money under the COVID relief for tribes, which is another example, I think, of the trust responsibility kind of kicking in, and it's really kicked in terms of money coming to tribes now because under this COVID situation. The big issue there is really whether that's going to stay around, whether we're going to have heightened levels going forward or not. Probably not to this level, clearly, but whether they stay up higher. And then I wanted to note that there's $20 billion of funding going to tribes under ARPA, and then there's another basically $1 billion going in under ARPA directly to housing, and then there's under the prior budget bill that was passed, significant money coming into the Native American housing block grants and into what's called Indian Community Development block grants. So a lot of money coming in. Really, all that money could be used for housing. It could be used for other things too, ones that are not housing. But you have a real opportunity to make a permanent change. One of the biggest issues, obviously, in any country is affordable housing. So the ability to do that, and then potentially to combine it with what I talked about before, with clean energy development, with the money from DOE and HUD and the tax credit money available, the ability to create housing you can provide low rents to the members, that's clean, good, new, and then also has basically zero energy costs. Because when you do those two things together, you have really affordable housing that can stay that way permanently. But I then wanted to just kind of note as I finish up that one last thing that the federal government has recently done, which is not directed directly at tribes, but the tribes can take advantage of, is that there's low-income housing tax credits that apply to housing for low to moderate income folks or low-income folks. In the past, there's always been there's been a two-tier program. There's 9% credits, which are extremely valuable, but extremely hard to get, and a lot of tribes have not been able to get it and take advantage of those very much. But there's also these 4% tax credits that looked pretty good in their face, because 4% means really it's over 10 years, so it's 40% of the cost of the project. So it could be like a huge grant coming in, the equivalent of that. But in the past, they really haven't been 4%. They've really been like 3%. They use a formula that I don't understand, but made it low. But now they passed the law to make sure that it will really be 4%. And then it can also be significantly higher. There can be an adder if you're in the right kind of census tract. So that, combined with all this ARPA money and all the money that's coming into housing in general, provides a real opportunity for tribes that want to be, aggressive about this, to develop a ton of housing where any cost share requirements on the federal grants are met by the 4% tax credits, and kind of vice versa, that you really can pursue significant housing now too. So just another example of how you can, how there are resources out there now in these kind of key areas of sustainable development for tribes. So that's it.
Thank you, John. Thanks, John. For those of you doing the CLE online, our second code word is strategy. And now we're going to hear from Reed Chambers, who is joining us remotely. I think Dylan's getting that set up. There he is. Reed, take it away.
Am I there? All right.
You're
Thank
here.
you,
We
Dan.
got you.
Good. Everyone, Dan, you can hear me?
Yes, we can hear you fine.
Okay, very good. Thank you, and thank you to the Wisconsin Law Review for honoring the restatement with this symposium, and for inviting me. I'm sorry I can't join you actually, but I do look forward to submitting an article to you in a month or so for your review. I'm going to talk about Indian water rights, which I think is very connected with economic development in this sense, that the theme of my talk is that the implementation and protection of Indian water rights as established by federal law is very often a necessary, not a sufficient condition but a necessary condition for economic development on reservations. So let me begin just by setting out the framework, which is well covered in the restatement, the legal framework of Indian water rights under federal law or protected by federal law. The leading case actually is over 100 years ago, a case called the Winters case. It was a suit by the United States against a man named Winters and a bunch of other non-Indians who were irrigating lands in Montana upstream from the Fort Belknap Reservation. The reservation was established by an agreement between the tribe and the United States, under which the tribe, or tribes, there are two tribes actually, ended up ceding land outside the reservation and agreeing to remain and confine all their activities to the reservation. This was right before 1888 agreement. Montana became a state in 1889. And then the United States opened the ceded lands outside the reservation for non-Indian settlement by Henry Winters and by other non-Indians. The non-Indians pretty quickly began developing irrigated agriculture on their lands. And early in the 20th century, the United States decided to develop, Bureau of Indian Affairs, to develop an irrigation project on the reservation for the Indians. And they found that the Milk River was running dry on the reservation and that there wasn't sufficient water reaching the reservation because of upstream irrigation. So the United States brought a suit to enjoin the non-Indian irrigators. The lower courts held for the United States on the basic theory that the setting aside the reservation by Congress approving the cession agreement reserved water sufficient for future needs on the reservation. Now, I need to teach you about 1 minute of Western water law, which is of course west of where you are. But not that far west. If you go to the Minnesota border, one state over, and then kind of draw a straight line down toward Amarillo, Texas, you have a situation where anything west of that line is generally a arid area or semi-arid area, a few exceptions on the Pacific coast. And the laws in Montana and those states under state law developed under a system of priority of appropriations. So that to have a water right in Montana, you need to make an appropriation and then you get ranked. Your priority date is when you start appropriating the water. If there's not enough water to satisfy someone junior to you who comes in later, you get all the water, they get none. It's a first in time, first in right rule. And of course, if that rule applied to the Fort Belknap Reservation, they'd be out of luck because the non-Indian irrigators had made the first appropriation. The Supreme Court held that essentially federal law preempted that state law rule, and that the United States intended, when it set aside the reservation, for the tribe to have sufficient water to come in the future when they needed it. And so the court enjoined the non-Indian irrigators, allowing sufficient water to reach the reservation for the uses that were contemplated in 1900. Now, having told you that much, perhaps you would expect, not if you knew nothing about Western history, that in fact, after the 1908 decision in Winters, there was ample economic development of water on Indian reservations, and large amounts of the water in Western streams were were used by Indians, but that is not what happened. In 1909, the year after the Winters decision, I'll give a few examples to illustrate it. The United States entered into the Boundary Waters Treaty with Canada because the Milk River and, of course, a number of other rivers are trans-border rivers, and then set up a commission to apportion the flows in those rivers. And for the Milk River, the United States made sure there were sufficient flows coming to the non-Indian irrigators so that with federally funded reclamation projects, they could keep going with their irrigation despite the seniority of the Indian legal rights. They provided no additional funding for development of the rights on the Fort Belknap Reservation. So today, actually, the irrigation on the Fort Belknap Reservation is essentially the same amount as it was 100 years ago. And this was common throughout the West. Arizona is a state where the United States financed non-Indian development projects to impound water upstream of the Gila and Salt River Pima Maricopa reservations in what are now the suburbs of Phoenix, that had been historically very productive agricultural reservations. I think actually tended to provide food for the original settlers coming into Arizona. But the United States financed non-Indian irrigation projects. And then when they brought litigation to determine what the water rights were of the tribes and of the non-Indian users, first the United States resisted any attempt by the tribe to intervene in the legislation, protect its own interests. And then second, they entered into a consent decree that awarded much less to the Gila River community and Salt River in two different decrees than they had historically used. Same thing in Nevada. Pyramid Lake is thought of as a major example. It's a desert lake that is the terminus of the Truckee River, flows from the Sierra Mountains down through Reno. And the tribe is primarily a fishing tribe and basically lived off unique fishing species in the lake. Federal government ended up building a diversion upstream of the reservation and financing it with a federal reclamation project, and then got involved in litigation to determine the rights of the users and the tribe, and didn't make any claim at all for the federally reserved rights of the tribe for fishing purposes, and entered into a decree that basically allowed most of the water to be diverted upstream. Another reservation in Nevada, Duck Valley, up on the Nevada-Idaho border, was a situation where the United States, again, funded large reclamation developments in a river that flows into the state called the Oahe River, and for non-Indians. And those diversions were making it impossible for the tribe to do irrigation and stock watering on its reservation. There, the United States actually had drafted a complaint in the Justice Department that the Bureau of Indian Affairs supported that would have confirmed the Winters Doctrine prior rights of the tribe. And the Bureau of Reclamation squashed the filing of the case. So again, basically the waters in that area were almost totally used by non-Indian users who were supported by many millions of dollars tens of millions of dollars a year throughout the West were spent in all administrations, really between Winters and the 1950s, to finance large-scale irrigation and municipal water projects, supplying non-Indians, and no provision was usually made in any of these projects for any protection of Indian uses or rights. Now, when I tie that to economic development, it's pretty clear that the prosperity of non-Indians in Western states in the first half of the 20th century was supported by large federal subsidies for federal reclamation and power projects. And of course, Indian economic development was greatly retarded by not being included in that and not being protected in any way by the United States. So, and tribes were not that active in those days. They certainly are now. So, I mean, I'm not making a claim, obviously, that the near universal poverty on Indian reservations, let's say in 1960, throughout the West was solely a consequence of the diversion of water for other uses and the failure to protect Indian rights. But it certainly contributed to the abject poverty throughout Indian country. When, 50 some odd years ago, I first started practicing representing Indian tribes. Now, things came about, two major changes came about, though, that I want to speak to. The second Supreme Court case dealing with Indian water rights is a case called Arizona versus California, decided in 1963 by the Supreme Court. And it involved, the Arizona versus California was a suit brought in the original jurisdiction of the Supreme Court by Arizona against the other lower basin states in the Colorado River, essentially to allocate the water between the states. And that's what most of the case was about. And but the United States intervened in the case. And among other things, intervened to assert the rights of 5 Indian tribes along the lower Colorado River main stem on the California, Arizona, and Nevada borders. As the case proceeded, the court considered the Indian rights. Arizona versus California basically followed the principles of Winters. It said that the Indians had a priority date for their water rights as of when their reservations were established. But instead of simply enjoining some non-Indian uses that might conflict with that, the court decided, and the special master hearing the case decided, that he had to make some definite quantification of the Indian rights to determine what's really left over then for Arizona and other states to develop non-Indian projects. So the United States then presented evidence as to what the largest Indian right might be. What could be the maximum Indians could use on these 5 reservations? Well, the most intensive use of water, generally in Western states, and I think pretty much anywhere, is for irrigated agriculture. So the government went out and presented evidence as to what could be irrigated on these reservations. They were right next to the Colorado River, a lot of water supply in the Colorado River. And so they made a claim for the practicably irrigable acreage on the reservation, what could feasibly be irrigated and produce economically viable crops. The result of that was a remarkable result, really, that the 5 tribes along the Colorado River were decreed a right to about a total of 900,000 acre feet of water. An acre foot of water is what it sounds like. Let's think of a swimming pool that is an area of 1 acre and it's 1 foot deep. Turns out to be 325,000 gallons. And that's enough water really to sustain a family in Madison for all its domestic and municipal uses for a year. So it's a lot of water. 900,000 acre feet is about 12% of the total flow, average flow of the safe flow, secure flow of the Colorado River in Arizona and California. So this was an enormous, stunning victory for Indian tribes. Now, as an aside, if there are any aspiring scholars, any of the law review students, if you want to do an interesting research project, it would be to look into the archives, or law professors in the audience, young law professors with energy. It was a really enormous turnaround for the Justice Department to make that argument. Contrasted to the 50 years of neglect of Indian water rights before that in the other cases. And it's a mystery. I don't have an answer to the mystery. I think it really does require burrowing into the archives of the what was then the Lands Division of the Justice Department, and probably into the historic records of Arizona versus California, how this came about. It's also clear that Arizona versus California was a great wake-up call for Western states, because they became very alarmed that Indian water rights might be very large and could come in and cut off the water uses that the Western states had been using, perhaps for decades. And at the other major change at this time of the Arizona versus California decision was an enormous turnaround in federal policy brought about by Presidents Johnson initially, and more cogently, I guess, or more comprehensively by President Nixon, in 2 messages to Congress, one in 1968, one in 1970, that inaugurated what we now call the self-determination policy. But essentially the policy of letting tribes control their own destiny, their own affairs on reservations. And Nixon, importantly, had a corollary to that, where he promised to have the federal trustee actively support Indian rights to natural resources. So beginning in the Nixon administration, the Justice Department set up a special section of lawyers skilled in Indian law, just to represent tribes as trustees against states or private interests. And that section still exists today. My friend Dale White, your prior panelist, worked in that section in the early part of his career very commendably. And that has made a huge difference in terms of just the federal government. I mean, the federal government no longer sits on its hands when an Indian water rights case is involved. Now, let's go forward. That since Arizona versus California, there has been a great deal of increased litigation concerning Indian water rights. Part of it sponsored by activism in the federal government, a lot of it sponsored by activism of tribes wanting to
Just want to let you
protect
know
their water rights.
There's about 5 minutes left, Reed.
Okay, yeah, I've been looking at my thing too,
Okay.
so I'll wind it up, Dylan. And the result has been cases that basically expand and confirm the principles of Winters and Arizona versus California, and those are summarized, I think, very well in the restatement. Now, what's going on outside the restatement, though, is that those cases tend to be very protracted. Wyoming litigated the water rights of the Wind River Reservation and non-Indian users in Wyoming and spent so much money doing it in the 1970s and 1980s that it discouraged other states from completing adjudications. There have been some that have been completed. But the major activity that's gone on for protecting Indian water rights has not been final judgments in litigation. It's been settlements of that litigation that's been negotiated very often with federal support. That's not something that's discussed in the restatement. But I think that I think it's fair to say most of the development in Indian water rights in the last 30 years has been the settlement of about 36 major cases, usually ratified by Congress, that provide federal funding for water delivery infrastructure on reservations and for increasing water supplies on the reservations. Interestingly, these settlements generally do not do what Winters did. I mean, they don't enjoin existing non-Indian uses. They don't cut off usually an existing non-Indian use to supply water for Indians. In fact, they usually are a trade-off between protecting in some fashion existing non-Indian uses in various ways and augmenting the Indian water supply, usually by repurposing a federal project or by some other mechanism that increases the Indian water supply. And this has been a sea change for economic development for the tribes that have been affected by the settlements. But as I say, there have only been about 36 settlements in 40 years, pretty slow pace. And the major, while that's made a real difference in the economies of those reservations, for the tribes that have not yet been involved in water settlements, there's still terrible needs. I mean, the large number. This morning, Troy was talking about the Navajo reservation. Half the homes on the Navajo reservation don't have running water, full kitchens, full bathrooms. So, and the recent effects of COVID on that reservation and others, where they're just not the basic facilities to wash hands, frequently, and that kind of thing, has really been a terrible impact. So I think that I'm not an economist, but I think a necessary condition for economic self-sufficiency on that kind of reservation is getting future water. It needs to be done, I guess, usually the mechanism is an Indian water settlement. And the process of the federal funding for these settlements needs to be greatly expanded. That finishes the 5 minutes, Dylan, so I will yield it back to you. Thank you very much for the opportunity.
Thank you, Reed. We do have about 15 minutes for Q&A. If I assume one of the students is monitoring the chat, in case there are any questions there, they'll let me know. And if you have questions here in the audience, Dylan's got the microphone.
Oh, thanks. Yeah, this is. Oh. Yeah, this is a very brief comment and observation that I've made. I was active in the water rights issue regarding the Keystone Pipeline and the aquifer in the Dakotas. And that had an unusual actor in that you had the involvement of the Department of State was becoming involved because that the basin also touched upon Canada. So it was the State Department that was holding the hearings on the subject. And that was interesting because they clearly don't have much experience for obvious reasons in conducting public hearings. And so that made for some interesting results. But I just wanted to remark that you do get sometimes these strange actors where indigenous water rights are involved. Thanks.
Thank you. And our online participants remind me that the post-Reed Chambers CLE code word is development. Development. Let's develop some more questions. One in the back and then one down here after that. Go ahead.
Hi, thank you. Thank you for your presentations. They're really interesting. My question is for Reed, actually. I'm curious whether you have concerns, as I do, that the exigencies of climate change at some point are going to trump whatever rules we have in place to protect Indian water rights as currently existing either under federal law or by treaty. And the situations will be seen to be so extreme. If you drive through the Central Valley of California, there are signs everywhere that without the dams, there will be no food. And it's sort of this apocalyptic call to change the underlying structure. So I'm just curious what you think about that. Thanks.
Well, thanks for the question. I don't like to think of any trumping of anything going on. But I think the climate change is enormously serious for the West. The Colorado River, which is the watershed that I've worked most on water rights, is really in a structural long-term drought now. People thought it was just kind of a cyclical couple of years, but it's been going on for 20 years. And it is a product of, because of global warming, you get a lot of problems. You get less snow in the mountains. And when you do get storms, they don't tend to melt in ways that replenish the surface streams. And of course, the reservoirs that store the water, they're enormous storage reservoirs along the Colorado River system, but evaporation increases in them. And so I think it's certainly right that the climate change will have a significant impact on Western water use and probably everybody's water use throughout the country. But I do think one thing I think is preservative on this is water rights are property rights. So they tend to be just legally a species of property. And those have a tenacity to them. I mean, you can't take a property right without payment of just compensation under the Fifth Amendment. A government can't. And a statute might be a regulatory taking if it tried to abridge Indian water rights. So from the Indian standpoint, I think that there is some protection in the legal tenacity of water rights as a species of property. I don't know if Dale or John have anything to add to that.
Yeah, I'll add a quick comment where you can go ahead and bring the mic to the next question down here. Oh, okay. And that is, the Native American Rights Fund, works on a lot of these water settlements. I know your firm, Reed, does as well. And we're seeing tribes take climate change into consideration when they're looking at the types of water infrastructure they want to build with their development, that if there's going to be less snow melt and less stream flow, do they need a larger containment facility to provide the water that they're going to need in the future? So there's an attempt to take climate change into consideration, but of course, so much of that is speculative. It's hard to really know whether you're actually planning. Dale or John, did you have anything more on this question?
I was just going to note, I mean, I guess the biggest issue to me, I guess, sorry. The big issue in this area, I think that relates to tribes and others too, is just how do we, kind of what you're saying, reconsider our use of water. And a big issue, I think, is going to be agriculture just in general. You know, how do you use less water for that intensive operation? I've been working on some projects that are looking at more like indoor farming, things like that too, that use a lot less water that we're going to probably have to think about as a country as we go forward. It's not just a tribal issue, it's just an issue overall that we're going to, if you do it based on percentages of the water, there's going to be less water to use, basically.
Yeah. So what's our online question, Dylan?
So a virtual attendee has a question. So if a tribe could impose and collect a sales tax, would non-Indians have to pay the sales tax to their state of residence?
Yes, and actually that was addressed in Colville. Colville was it took and then it gave away. One part of its decision affirmed the right of tribes to impose their taxes even on non-members. And then the other part of the decision was the bad part. So clearly tribes, part of the bundle of rights that tribes have is the sovereign right to impose taxes on non-members doing business within the community.
Question down in the front.
Yes, it has to do with whether extraterritorial fishing rights and other rights that are preserved by treaty are somehow integrated into the water rights arguments by tribes.
Well, yes, they have been. A number of cases have involved tribal claims, for example, to protect in-stream flows, not to keep water from being used, in effect, to sustain their fishing rights, and particularly the tribes in the Pacific Northwest tend to have fishing rights that go outside the boundaries of their reservations. So it is often a component of a water rights claim to protect in-stream flows to sustain fisheries. And that's been involved in several cases. None has reached the Supreme Court.
I'll just quickly add that the restatement in Chapter 6 does have several sections on tribal hunting and fishing rights that kind of fit under the umbrella of this panel, but none of our panelists specifically were addressing it. That's where you would find it in the restatement. Other questions?
Hi, this question's more for Dale and John. And so my undergraduate degree is in engineering, and as a native engineer, talk about this clean energy and whatnot. And my hope would be that tribes at some point would hold the patents on some of these some of these new technologies. What would that realm look like? Would that be an extension of tribal sovereignty to enforce patents? Are tribes allowed to enforce patents? For economic development.
And Dale has been involved in a lot of litigation in this front. So Dale, talk about patents.
Speaking as a member of a tribe that for a year and a half owned the Restasis patents, I can try to answer that question. Rather unsuccessfully tried to hold the patents. It would all be governed by federal law under the U.S. patent system. So the tribe could not independently apply and develop its own laws for patent. It would just participate in the general marketplace or system for patents. But certainly there's no reason why a tribe couldn't do that. Our case actually involved protection of a patent, and we bought the patent, acquired it from Allergan, and then did something that states were allowed to do, which was protect it by sovereign immunity. And then quickly Congress sprung into action, and then eventually lost the case in court. So anyway, hope that answered your question.
Probably got time for one more question.
I actually had a question.
Go ahead,
myself.
Dylan.
So the infrastructure bill that was passed, I think yesterday, John, I think you kind of briefly mentioned it in your presentation. I'm wondering, what provisions in that bill, if there are any at all, kind of empower tribes to build up water and like housing resiliency.
Yeah, so there's within that bill, there are provisions that there's just so everybody's aware, at the same page, there's two bills that are at issue here. One is what they call a bipartisan, but really passed on a partisan basis, I guess, yesterday, which is a $1.2 trillion bill. And then there's also the kind of social justice type bill that includes climate change more directly. There is, though, money for transmission, electrical transmission, and this, I think it's 7.5 billion, as well as for electric vehicles, another 7.5 billion, I think, and then for charging. For charging, which is 7.5 billion as well. So there's a lot of money there that tribes could go after for those kinds of things, basically to help. And one tribe we're talking right now, they want to get more. They're looking at getting more involved because there's transmission planning that goes on, and a key issue for tribal economic development also is access to the grid. There's also kind of I guess you call it NIMBY, and also legitimate concerns about where lines go through and affect, for tribes, culturally important areas, environmentally sensitive areas, and for others too. But they're looking at, do they want to help through the money that'll be available to get involved in the process, try to bring in one or more lines that can either through the reservation or close to the reservation. That allows them to potentially buy energy cheaper if they can buy it directly from transmission. That could be clean energy from like the Dakotas, the wind farms and stuff that are out there, perhaps from other tribes, actually. Then they're also thinking about, do we put in large energy storage? Because then we could control energy and sell it when it's scarce, basically become kind of like a mini OPEC for clean energy, which could be very valuable as well. So there's a lot of opportunities to think about there. I think the big thing, though, is if the second bill passes, there's going to be a lot more in there that tribes can take advantage of too in the energy.
And just to jump in, I've got one more question. So we've talked a lot about sovereignty. I'm not really sure how it works exactly for public-private partnerships, but are tribes able to enter into those kind of long-term use agreements and development kind of agreements?
Yeah, tribes can enter into, like, for instance, in the energy area I work in, typical arrangement is a partnership, basically. Everybody uses LLCs now, limited liability companies, but they're really just partnerships. And typically what's done there is that the taxable entity early on oftentimes is a 99% investor. That's the same thing for low-income housing tax credits projects, same thing for energy projects, and can be for other projects too, where there's some kind of big tax benefit that can be taken advantage of by the taxable entity. And the tribe often then is a 1% entity in those. Again, the restatement talks about these business structures a little, a lot actually. And the use of, typically they're state chartered entities because you're bringing in a non-tribal entity that would be more comfortable that way. But then there's also usually some kind of plan for an exit by that entity as well. So like, for instance, on the energy stuff, you need them around for about 6 years, 5 or 6 years, because there's a recapture of the tax credits if they leave early, and because you want to fully monetize the depreciation that's there too. But then once that's done, you usually work out some kind of arrangement for a transfer out, either a sale from the LLC of that project or a takeover of the LLC essentially by the tribe.
And that can vary based on what kind of business it is too. Some of the Indian mineral statutes provide for their own types of both tribal organizations and tribal joint ventures, tribal partnerships. So there are a number of frameworks out there, and sometimes it depends on what kind of business you're in. That brings us to the end of our time. I've got one more word. It occurs to me that the law review should have ask for donations of $10 for each code word, but instead I'm going to give it to you free. The last code word for CLE for this panel is fund, F-U-N-D, fund. Thanks everybody. Dale, Reed, John, thank you for your insights.